for the confirmation of Honorable Justice Walter Onoge for the appointment of Chief Justice of the Federal Republic of Nigeria in accordance with Section 231, subsection 1 of the 1999 Constitution. Now, that is just not all. We also have at least one report that will be laid. There will be 3 motions, and there will be, yes, over 9 bills that will go for second reading. Now, how is this going to play out? We felt that you should hear from one of those that should have a say on daily proceedings. Sir, we are privileged to have Senator Olushola Adeyeye. He is the Chief Whip. He is a senator representing Osun Central. You're welcome, sir.
Thank you very much.
Yes, let us start, sir, with the confirmation of the nomination. It has generated a lot of interest for the nation. Now, how did the interest came about, and then how has it been resolved?
Well, the interest is a question that is normal. Allegations were made against the nominee, and allegations remain just that, allegations. When you make an allegation against anyone, that person should be given a chance to defend himself. I am not sure what process the executive went through before the nomination was sent to Senate. One wants to assume that the office of the president had done due diligence. It is now the turn of the Senate to do the same, to look at the issues which have been raised in public domain, to ask questions and to listen to the answers of the nominee and to take a decision that is fair to the nominee and fair to the president and fair to the Senate, but most importantly, fair to the Republic that we all swore to serve.
What will you say to some people that are maybe speculating that possibly he will be asked just to take a bow and go?
I don't think that will happen. Okay. And that should not ordinarily happen, particularly because of what you have called widely generated interest in the public domain, whether you are talking about the mainstream Nigerian news media or you are talking about the social media. There have been a lot of speculations, arguments for and against. You've had legal luminaries pontificating about even the process by which we nominate and confirm our Chief Justice. This particular one, in my mind, is very important because unlike some of those who have been nominated in recent times, his age will allow him to serve for more than just a few months. Some of those who have served in recent times have had extremely abbreviated tenure. But in this case, you have a man who is about 66 years old, and by the rules of the appointment into the Supreme Court of Nigeria, they all have the opportunity, if they so desire, to serve to the age of 70. So this man will have at least over 3 years as our Chief Justice if he is confirmed, and therefore there should be a critical evaluation of his nomination. And I'm sure the process will be fair to him and fair to the Republic.
Okay, aside from this, can you whet the appetite of our viewers as to what else to expect aside from this?
Well, today we will also be hearing 2 motions. One on the ECOWAS. You know very much that Nigeria was in the forefront of the formation of ECOWAS with our then head of state, General Yakubu Gowon, being in the vanguard and spearheading the effort for the formation of ECOWAS. Some of these laws now have to be either updated or domesticated for the purpose of bringing it into conformity with international best practice. We also have a motion coming on the process by which NNPC remits money to the Federation account. A senator rose yesterday to point attention to some discrepancies in that process, and I'm sure that Senate will look at this very, very critically today.
Wish you happy deliberations, sir.
Thank you very much.
Well, that's just the tip of the iceberg. For the main dish, the main demand, we'll hand you over now into the Senate chambers for live proceedings. Happy viewing.
and the executive of these member countries. And this will further enhance and give authority to the Parliament to perform its function without let or hindrance. And I am of the opinion that any attempt to elevate what has hitherto been below what is obtainable around the world should be supported by this Parliament. I'm therefore of the opinion that it's so straightforward that we do not need to waste so much time on this matter other than to just take the two intents of the motion and to accept the fact that it is reasonably necessary at this time of our history as a Parliament. I therefore urge that all my colleagues support this straight motion without any debate. Thank you. And conclusively, I therefore ably second the motion as ably moved by the Deputy Senate President, the ECOWAS one.
Distinguished colleagues, I think it's a pretty straightforward motion. Let's go straight to the prayers. Prayer 1, commend the ECOWAS authority of the heads of states and government for finally enhancing the powers of the community parliament in line with international best practices. Those in favor of prayer 1 say aye. Those against say nay. The ayes have it. Prayer 2, commend this as a major achievement towards the democratization of the governance of the sub-regional body and promotion of the fine principles of separation of powers and checks and balances. Those in favor of prayer 2 say aye. Those against say nay. The ayes have it. Congratulate the community parliament on this milestone. Those in favor of prayer 3 say aye. Those against say nay. The ayes have it. Prayer 4, commend all the organs of the ECOWAS and individuals who championed the cause, worked tirelessly and made personal sacrifices towards the actualization of a true parliament for the people of West Africa. Those in favor of prayer 4 say aye. Those against say nay. The ayes have it. Prayer 5, commend members of the international community, especially the various international organizations and development partners which supported and committed their resources towards the achievement of this feat. Those in favor of prayer 5 say aye. Those against say nay. The ayes have it. And prayer 6, call for the amendment of the Electoral Act of the Federal Republic of Nigeria to empower INEC to conduct election to fill the nation's 35 seats at the community parliament. Those in favor of prayer 6 say aye. Those against say nay. The ayes have it. Additional prayer. Yes, Philip Aduda.
Thank you, Mr. President, distinguished colleagues. We thank the ECOWAS for giving us the 35 seats. But however, Mr. President, there are 36 states and including FCT, making it 37. So if we were to go by state, one for each state, there will be 35 states and one state will be missing, and then one which is supposed to be federal capital will be out of it. So my additional prayer would be that ask them or urge them to add 2 more seats to make it 37 seats. That's my additional prayers. Thank you, Mr. President.
Anybody seconding the prayer? Distinguished colleagues, let me thank the Deputy Senate President for this motion. Let me also join others to say this is a major achievement in our sub-region. The endorsement by the heads of states and government of the ECOWAS on the Supplementary Act truly enhances the powers of the ECOWAS Parliament, and is indeed historic and very, very commendable. I want to thank all those that worked towards it. I thank our own Deputy Senate President and the leadership of the Parliament. This is something we should all be proud of. It's a victory not only for the legislative democracy, but I think the coming together of the ECOWAS body into a more people-orientated and focused assembly. And we charge the regional body to take advantage of this to ensure that we continue to work for the actualization of regional integration. Leader of the Senate.
Mr. President, very distinguished colleagues, the second order of the day is a motion standing in the name of Senator Dino Melai on the discrepancies in subsidy payment and non-remittance of funds by the NNPC to the Federation account. Mr. President, you may wish to invite Senator Dino Melai to move his motion.
Senator Nominee.
Mr. President, my very patriotic colleagues, my name is Dino Melaye, Kogi West. Mr. President, I yet again rise in pain to move this motion once again in the course of our nation's history. Mr. President, very, very patriotic colleagues, the Senate, aware that majority of Nigerians overwhelmingly agree to fight corruption, and this informed the present administration's resolve to tackle the widespread corruption in all its ramifications, inclusive of the petroleum industry. My respected colleagues, the Senate notes with dismay that despite the crackdown on corruption by the present government led by President Muhammadu Buhari, there has been continuous violation by the Nigerian National Petroleum Corporation, NNPC, as regards non-remittance of proceeds from the sale of refined products into the Federation account. This practice is similar to the problems that sparked the national outrage against the last administration. Mr. President, the Senate is aware that though independent marketers account for 49% of imported petroleum products, while the Nigerian National Petroleum Corporation, NNPC, account for 51% of imported products, but this does not justify the huge amount it has been paid as subsidy in the last 10 years. My respected colleagues, the Senate is concerned that from the records derived from NNPC, 5 to 10 cargoes of imported crude arrive the country monthly, while about 5 cargoes are refined locally, and each cargo contains 5.8 million liters of refined crude products. Mr. President, my very respected colleagues, the Nigerian Senate is worried that the excess products which cannot be dispensed, that goes into different tank farms owned by private individuals, are not properly accounted for, as they are illegally sold off by the owners of these tank farms in manner that is opaque and usually designed to rip off the public and enrich a few persons stupendiously at the expense of the masses of this country. The Senate is disturbed that since this administration clamped down on subsidy payments, NNPC has solely been responsible for retail with companies like Bovas and Rano Oil paying 20 to 25 naira per liter for the sale of this product, which amount to over 2 billion naira monthly. Mr. President, my respected colleagues, the Senate further disturbed that these monies are not accounted for, and that might be the reason why we now see petrodollars buried in caskets and uncompleted buildings in remote villages in some parts of the country. Mr. President, the Senate accordingly resolved to mandate the Committee on Petroleum Downstream to exhaustively review and investigate the NNPC over its accounts relating to fuel subsidy and the abuse of the abuse of product marketing and distribution between 2006 and 2016. Mr. President, the Senate is the hope of the Nigerian people. This morning again, There is a clarion call by the Nigerian people on distinguished Senator Dr. Bukola Saraki and his colleagues to help again in the fight against corruption. Are we going to accede to this call? As I speak to you, Mr. President, some of the monies we are mentioning here could be part of what was found in Sabon Tesha in southern Kaduna recently. Mr. President, the Nigerian Senate must, as a matter of urgent national importance, curb these corruption, block wastages and leakages in the system. We cannot get out of recession if the fight against corruption is not fought headlong. We will continue to expose corruption here, but it is also mandatory of the Nigerian Senate to make sure that those found wanting are not only prosecuted, but they face the full wrath of the law. Mr. President, if we don't kill corruption, corruption will kill us. Mr. President, I appeal to us, because I am again tempted to cry before this chamber. I appeal to my colleagues that this cankerworm must be fought to stand still this time. This investigation must be the last and permanent solution to the corruption in the oil industry. This must completely be separated from what happened in the subsidy investigation in 2011. I appeal to us that these leakages must be blocked. Every Nigerian found wanting must be prosecuted. We must salvage our economy. We must plan for the future of generation yet unborn. And the time to do it, Mr. President, is now. Thank you very much. I so move.
Senator Albert Bassi, Akwa Ibom, noticed.
Thank you, Mr. President. My distinguished and respected colleagues, Mr. President, I remain Senator Albert Bassi, representing the good people of Akwa Ibom Northeast. Mr. President, I rise to second this motion and to state very clearly, Mr. President, that there are two challenges that is facing the Nigerian economy. And that if we are committed and we are determined to recover our economy from recession, then two things must be taken into consideration. The attention we pay to issue of petrol product price deregulation, as well as our interest rates. The interest rate, I don't know the miracle that the CJN is doing, but I think we are beginning to see progress in that regard. But Mr. President, let me state clearly that the content of this motion is extremely very grievous. I am equally aware, Mr. President, that as we speak, NNPC is indebted on first subsidy to independent petroleum marketers as well as the major oil marketers to the tune of about $1.4 billion. And most of the challenges we have in our financial institutions today is as a result of these outstanding obligations of product importers on the banks. There is no bank in this country today that can be said to be very healthy because of the outstanding liabilities of petroleum products marketers. And as we speak, Mr. President, it should also be placed on record that the government of the Federal Republic of Nigeria had actually issued a sovereign guarantee to these product marketers that any debt owed the marketers as a result of the importation of petroleum products will be paid by government. So this $1.5 billion amounting to over 600 and something billion naira is a liability to government. So I support this motion in totality, Mr. President, and this is the reason why, as we speak today, NNPC is the sole importer of petroleum products, and these products are being imported into the country at a loss. It is on record that in the last 3 to 4 months, we have incurred over a loss of about 120 billion naira
on imported petroleum products. So I support this investigation, Mr. President, and I urge all my colleagues to support this investigation so that we will display that courage that will sustain and help this country. We must protect the interests of all Nigerians for the good of all. Thank you, Mr. President.
Senator Sekibo.
Mr. President, and my distinguished colleagues, I am Senator George Thompson Sekibo, CON. I represent the Rivers East Central District. Mr. President, when motions like this comes up, it grieves our heart. Why do I say so? Nigeria ought to be one of the richest countries in the world. As one of the greatest producers of oil and hydrocarbon and gas. But today, it is noted all over the world that we are in recession. And after recession, depression comes in. After depression, what comes up? There may not be a country. Now, years ago, Nigeria had oil boom. Virtually in every 5-10 years, God raised an opportunity for the country to be richer. But because of leadership, people were entrusted with the revenue of this country and are not spending it prudently, harnessing it prudently. That is why we have gone down the drain to this recession. Mr. President, I want to refer us to the Constitution. Section 15, Section 15(5). It says this: the state shall abolish all corrupt practices and abuse of power. Recently, they dug in somebody's pit and got billions of naira. That was a man that was also in charge of the same industry. Today, similar events are coming up. If we don't work hard, investigate properly, and call to book whoever is guilty, then this trend will be continuing. Mr. President, if you look at Section 16 of our Constitution, subsection 2, B and C, that the material resources of this nation are harnessed and distributed as best as possible to serve the common man. When few individuals are making 2 billion in a month, 24 billion in a year, and then the others are lavishing in poverty, can that continue as a good country? Therefore, we call on you today to be sure that the investigation that will be carried out today on this matter be prudently done to the last, and if any person is found guilty, such persons must face the wrath of the law. I take it to Section 16(2)(c), that the economic system is not operated in such a manner as to permit the concentration of wealth or the means of production and exchange in the hands of a few individuals or of a group of people. Mr. President, that's where the problem comes. When one man is harnessing $9 billion, when few people are getting $1 billion in every week, how can we come out of this recession? For us to come out of this recession is to join the president wholeheartedly and fight this corruption battle sincerely. I so support. Thank you very much.
Distinguished colleagues, I think this is pretty straightforward motion. So we'll go to the prayer. Prayers is to mandate the Committee on Petroleum Downstream to executively review and investigate the NNPC overseas accounts relating to the fuel subsidy and the abuse of product marketing and distribution between 2006 and 2016. Those in favor of prayers say aye. Those against say nay. The ayes have it. Any additional prayer? No. Distinguished colleagues, let me thank Senator Dino Milaya and all those that contributed to this motion. As said by those that contributed, this motion borders on the issue of corruption in the most important sector of our economy, which is petroleum sector. We must get to the bottom of these acts, which I would like to believe that they're not institutional, or where individuals just believe that they can do what they would like to do and are not accountable to anybody. I want the committee to investigate this thoroughly, prudently, and I want all the members of the committee to ensure that a thorough job is done and to ensure that we get a report to tell us exactly what is going on. We cannot continue in a country where people will continue to add hardship to our people just because of their corrupt practices. So the chairman of the committee and members, please ensure you do a thorough job and bring a report to us as soon as possible to get to the bottom of this situation. Thank you. Leader of the Senate.
Mr. President, very distinguished colleagues, the third order of the day is a motion standing in the name of Senator Philip Aduda and Senator Dino Melaye on the continued implementation of the Federal Capital Territory Statutory Appropriation Act 2016 and for other related matters pursuant to Section 122 and 299 of the 1999 Constitution of the Federal Republic of Nigeria as amended. Mr. President, you may wish to invite Senator Philip Aduda to move the motion.
Senator Aduda.
Thank you, Mr. President. Thank you very much, distinguished colleagues. This motion is co-sponsored by me and distinguished Senator Dino Melaye, the chairman of the Committee on the Federal Capital Territory. It's a motion for the continued implementation of the Federal Capital Territory Statutory Appropriation Act 2016 and for other related matters pursuant to Section 122 and 299 of the 1999 Constitution of the Federal Republic of Nigeria as amended. The Senate notes that the FCT Appropriation Statutory Act 2016 was passed on 20th July 2016. Notes further that the bill was assented to by the President, Commander-in-Chief of the Federal Republic of Nigeria in August 2016. Further concerned that the FCT Appropriation Act operated for only 5 months before it elapsed, that is 31st December 2016, as captured in the 2016 FCT Statutory Appropriation Act. Observe that the FCT has been indicted with complaints of non-payment for infrastructural development, satellite town developments, and city cleaning services due to budgetary constraints. Also observe that the city has slided into environmental embarrassment, especially the Whooper sewage treatment plant. Note that Section 122 of the 1999 Constitution of the Federal Republic of Nigeria, as amended, provides as follows. If the appropriation bill in respect of any financial year has not been passed into law by the beginning of the financial year, the governor may authorize the withdrawal of monies from the Consolidated Revenue Fund of the state for the purpose.
Senator Philip, could you stop for a second? Distinguished, we can't definitely conduct the plenary session like this. Let us respect the chamber that we are and also respect our colleagues. Thank you.
Thank you, Mr. President. Consolidated Revenue Fund of the state for the purpose of meeting expenditure necessary to carry on the services of the government for a period not exceeding 3 months or until the coming into operation of the law, whichever the earlier, provided that the withdrawal in respect of any such period shall not exceed the amount authorized to be withdrawn from the Consolidated Revenue Fund of the state under provision of the appropriation law passed by the House of Assembly for the corresponding period in the immediately preceding financial year, being amount proportionate to the total amount so authorized for the immediately preceding financial year. Note further that Section 299A of the 1999 Constitution of the Federal Republic of Nigeria, as amended, provides as follows. The provision of this Constitution shall apply to the Federal Capital Territory, Abuja, as if it were one of the states of the Federation, and accordingly, all the legislative powers, the executive powers, and judicial powers vested in the House of Assembly, the governor of a state, and in the courts of a state shall respectively vest in the National Assembly the President of the Federation, and in the courts which by virtue of the foregoing provisions are costs established for the Federal Capital Territory, Abuja. Accordingly resolves to draw the attention of the Federal Capital Territory Administration to the provision of Section 122 and 299 of the 1999 Constitution of the Federal Republic of Nigeria as amended, authorizing them to continue to spend money based on the previous Appropriation Act up to 6 months from the 31st day of December 2016 or until a new budget is passed into law for the FCT. I so move, Mr. President, distinguished colleagues. Thank you very much.
Yes, Senator Nominee.
Mr. President, my colleagues, Dino Milai, Kogi West. Mr. President, the motion moved by distinguished Senator Philip Tenimo Aduda is a very straightforward motion. The Federal Capital Territory is the seat of power, and as I speak to you, they are operating in pain because they cannot spend money because the Appropriation Act for the FCT was passed only in August or signed into law in August last year. So there's an impediment to the operations of the FCT, and they cannot spend since the 31st of December elapsed. And in consonance with the provisions of the Constitution as provided in Section 229 of the Constitution of the 1999 Constitution, we are seeking for just the resolution of this Senate to extend the financial year of the FCT so that all the operation of this city will not cease. I want to please call on my colleague in the interests of Nigeria and the Federal Capital City to please pass this resolution so that the monies in the coffers of the FCT will be properly spent for the benefit of
doing so, then I think that it's already implied that if the FCT doesn't have a budget yet for 2017, that they will continue to spend money until they have a new budget. I think that's what it is. So I really don't think that it would require really having to do a resolution of the Senate for them to do what the Constitution says they should do.
Deputy Senate President.
Thank you, Mr. President, distinguished colleagues. As stated by the mover,
Utilize the budget for the interests of the people in the FCT. So it will be your responsibility, and also call the minister and the executive in charge to know that they should ensure that they do implement the budget of 2016 and for the interest, and no excuses should be accepted or taken now that we've done this. Thank you. Leader of the Senate.
Mr. President, very distinguished colleagues,
Leader of the Senate.
yeah.
Mr. President, in the chair, very distinguished colleagues. Secondly, I move that the Senate do admit the Cross River State Governor, Special Advisor to President on National Assembly matters, and the nominee and other judicial officers into the chamber, into the Senate chamber.
Senator Adokwe, please take your seats. Senator Adoko, please, you are delaying Senate business. Please take your seats.
Don't call my name. Don't call my name.
Please take your seats, distinguished colleagues. Senator Emmanuel Pokra, please take your seat. Senator Marafa, please take your seat.
Senator Bukaraba Ibrahim, please take your seat.
Senator Bukar Ibrahim, the Senate President is waiting for you. No, there's no gubernatorial immunity in this chamber. Distinguished Senate President, we are set.
Thank you, Chief Whip. Distinguished colleagues, we are with us this morning the Acting Chief Justice of Nigeria, nominee for the position of Chief Justice of Nigeria, Honorable Justice Walter Samuel Ekano Onoge, CFR. My Lord, you are welcome to the Red Chamber. We've all been given a copy of his CV, which I think you've had the opportunity to go through. As our practice, my Lord, will allow you first to tell us a bit about yourself, and also if there are things in your CV which has been omitted, which you think will be relevant for us to know about, you can say that. And after that, I'll ask my colleagues that have any questions to ask you the questions, and then you respond. The questions will be from our colleagues, and if there are any questions you're not clear about, you do let us know so that they can say it again or repeat it as case may be. This is a judicially friendly chamber, so please feel relaxed. Over to you, sir.
Thank you very much. The Senate President, Deputy Senate President, Senate Leader, the Minority Leader, distinguished senators, to continue my education, I was at Odogono Boys Secondary School at Abraka, Accra. I had my first school leaving certificate, my school certificate in 1972 in that school. I proceeded to Accra Academy, where I did my higher school certificate. I completed it in 1970. In 1998, I was elevated to the Court of Appeal while sitting as a tribunal.
The lifespan of the tenure of the incumbent. But after we amended the Constitution, giving time frame to deal with that, some other parts of political-related matters got caught up in the web of long periods of trial. Now, matters such as the internal dynamics of the party, post-election, pre-election matters, they are pending all over the courts and taking so much time.
We all believe that we have three arms of government. And of course, we enjoy our independence to some extent. But we make laws and you interpret them in the judiciary. I want to suggest that we should build a closer working relationship. That is the legislature and the executive delegation, but we need to do something to regain confidence of the public. With this, I want to thank you and wish you good luck.
Maila, maybe I think you take those sets of questions. Yeah.
Much. Distinguished senators, Senate Leader, And election-related matters, they ought to be heard expeditiously. So whenever they come to the Supreme Court, we've been dealing with them that way. And so far, I've enjoyed the tremendous cooperation of the justices, and there's much improvement. I will confess that today they are not sitting because they are all here. I don't see much of the corruption matters as such, but they are there. And from the explanations they have given from the database, well, I believe it takes three to have an effective and efficient judiciary. Criminal prosecution, for instance, you need to have an effective and efficient investigator who will investigate first before charging you to court, gets his evidence. You need a prosecutor who will go through this, when the investigator brings this report to him, he should go through it and decide whether it has any weight. Then you have the judge, who is the final piece of the puzzle. So when matters that get to court that are properly are ready for trial, actually you normally see them moving from day to day and expeditiously. So actually it is the government. If the government wants to establish any court and how many courts, the judiciary wouldn't say no. But I believe if we can put our acts together and do the right thing, carry out proper investigation before charging a man to court. And when you judiciary deals with laws, the Constitution, the laws and the regulations, and it shouldn't be seen to be acting outside the purview of these regulations. So within that compass, I assure you that we have strong willed, determined judicial officers of unquestionable integrity that have put in all that they have in the service of that arm of government. And I believe that the Nigerian judiciary will come out of the present situation stronger than ever before. Then there is a suggestion, okay, it is a very good suggestion that there should be a kind of cooperation between the legislature and the judiciary. In fact, should equally be extended to the executive, because these three arms belong to one body, the government. The government is made up of these three arms. So there should be some understanding between them, because some of the problems we face are not really worth it if they are subjected to a little bit of discussion here and there at certain levels. So it could be, on my part, I will encourage it, but not to the extent of compromising the integrity of the judiciary, because the judiciary remains the last hope of the common man. In fact, everybody is a common man in the eyes of the judiciary. That is why that lady is blindfolded. He doesn't see who is coming. He doesn't need to see him. Yes, the corruption charges, I have answered that in the way I dealt with the other district. So the charges are there. Well, they are being tried, and being sub judice, I think you will excuse me not to comment on that, so that I would not be liable for contempt proceedings. Thank you, Mr. President of the Senate.
Senator David Moro.
Thank you, Mr. Chairman. My name is that scenario put against the recent arrest of some judicial officers for alleged involvement in corrupt practices. And following the delay in your nomination by the executive, as justices of the Supreme Court, similar invitation was extended in respect of the Court of Appeal. Could you explain the reason behind this departure from tradition of elevating justices of the lower court to the Supreme Court and its likely effects on the morale of judicial officers
for finding you fit to take over and to maintain the tradition of the Supreme Court and the judiciary in ensuring that the most senior amongst you become the CJN, which had been the norm before your emergence. I must also say that, judging from your record, that you had a fantastic questions. Yes, so if they are listening, they may not need to ask further questions. So one of the problems I have is that mine is actually, how are you going to reinvigorate the confidence of the public in the judiciary based on the fact that we have had instances of same facts, with the almost, in fact, same facts coming before through court and divergent decisions emerging. For instance, the public seems to have more confidence in the Supreme Court than in all other courts below the Supreme Court. That is a fact. I'm saying this especially, okay, let me not be too specific. Why I'm mentioning this, sir, is that take, for instance, very recently, we had a situation in Port Harcourt where we received judgment. And of the 3 justices of the Court of Appeal that sat, 2 of them emerged with handwritten judgments in a very crucial matter. And they read their handwritten judgments within 10 minutes each. And so they carried a day. But the minority judgment took 1 hour 45 minutes and did a thorough job of picking on the issues one after the other, to the amazement of all. When we see such a thing, it tends to give the impression that this particular handwritten judgment of 10 minutes, 5 minutes, were afterthoughts. Nigerians want to see an independent judiciary. So far, we believe we are doing a good job under the circumstances. With your confirmations, we are yet to really fully go into 2006 cases that had to do with commercial matters. And this does not give confidence to investors who are coming into Nigeria if their cases are over-delayed. Then finally, sir, from the side of politics, we believe that the judiciary can help us to strengthen democracy. And we are worried right now that the judiciary, yes, is an arm of government, but we don't want the judiciary to be pocketed by a political party. Because I do know that when we had the opportunity of being in charge for over 16 years, the judiciary had a very independent judiciary, and a lot of decisions that came out were not politically motivated. Am I speaking your mind? Yes. So today we are worried that we would like to say, no, I don't want to mention names of judges, but we want to see more action on your part in dealing with issues where clearly a judge will put himself in the arena and deliver, give decisions that even the plaintiff will not ask for, including adding a wife to the plaintiff in his ruling, and then personalizing issues, as done very recently. So we are worried, and would like you to see sanitization. What reforms are you going to bring? How are you going to talk to the courts below you? And at the same time, sir, we have confidence in you. We have confidence in the Supreme Court. We want to have confidence in the Court of Appeal. We want to have confidence in the High Court and all other courts below you. Congratulations on the elevation. Thank you.
My Lord, maybe you take those questions, yeah.
Thank you very much. On the question of delay in my appointment, subject to confirmation, because the nomination had already been done by NJC. That one, I can't tell. But eventually, it was done. And here we are today. So on the fear of and the judiciary of any nation at all. But when we approach the system and thinking that, oh, there's always something wrong somewhere and things like that, that is where the problem lies. So that is why I wouldn't say more on that. I'm sure that so I assure you that the independence of the judiciary will be continued. The independence of the judiciary will continue, and that under my watch it will be reinforced. That one is there's no compromise on that, because you see, I said it earlier. If you don't have an effective and independent judiciary, you cannot talk of the society itself. You say that the judiciary is the last hope of the common man. It's the last hope of every man, because justice is blind. It doesn't look at who is coming, common or uncommon. So, yes. Then the question of MBA, the system had been there, you see, but there are some talks. I shouldn't be allowed to answer this question because there are arguments for and arguments against. At the moment, there are arguments for and arguments against. So, as an umpire, I should reserve my opinion to when the decision is going to be taken at the appropriate time. But I want to tell you that if there is no lawyer, there is no judge who is not a member of the bar. There is none. Every judge is a member of the bar. But joining the bench is where you have age differentials. If you are a member of the bar and you made 10 years post-call, you are qualified to be a judge of the High Court. If you made 12 years, you are qualified to be a judge.
My Lord, I thought you said you wanted to not answer the question. I just wanted to remind you.
So, 60 days, we are already, you know, I had a complaint. I had a courtesy call from a group that deals with these commercial matters, talking about the delay in commercial matters. So, but I want you to know that we have in place practice directions, even in the Court of Appeal and the Supreme Court. But when they came in and made that complaint, I called for the records. And to my greatest shock, the cases they were talking about had not yet landed on the Supreme Court bench. They had not gotten to us. So whether they are in 2016, they have to travel to our court. When they come to the Supreme Court, we already have in place a machinery to expedite their hearing and determination. So we are ready. We are prepared for that innovation. The conflicting judgments, the conflicting judgments they are bound to happen, because when you sue before Judge A in Abuja and you go to Sokoto and sue before Judge B, different party, but on the same subject matter, and you file your processes in Abuja, not the same processes, but different processes in Sokoto, as that lawyer sees it, the judge in Abuja may decide to allow the application, while the one in Sokoto may decide to dismiss it. Now, the system has its own regulatory mechanism through the means of appeal. That is how we resolve these things. But to think that we can do away with conflicting judgments in a judiciary, every judiciary in the world, is not going to be possible. So that is that. But the aspect of the particular case he's talking, I think the matter is still sub judice, and I should be excused from commenting on it. So 21, okay, the appointment, that is taken care of by what I said earlier on in terms of making the number up. I can say that there are moves to make it up, the required number. We are looking into that. So pocketing the judiciary, as I've said, is not going to be possible. It has never been possible, and I don't think it will be possible under my watch. Because as I said, that will be the end of this country as you know it. The moment you politicize the judiciary, then you finish. Everything is finished.
Senator Theo Oji.
By timeously addressing certain decisions that certain people found to be unconstitutional based on the United States Constitution. And they approached the court, and the court became decisively definitive. And that led to rest what will have been a very serious international crisis. Do we expect can shield the entire institution from what it is going through at the moment? I hope I have made myself clear.
Chief Whip.
Thank you very much. I have three quick questions. And on behalf of the non-lawyers, I will show that non-lawyers can ask questions. Why are members of the bench nominating and getting involved on who should be SAN? Because you have some sand boasting about the whole place that they have the support of this or that member of the Supreme Court before whom they will eventually appear. Can we have sands emerging solely from members of the bar? Once you say you are moving from the bar to the bench, leave the seniority of the bar alone. Last question. Remember, this is not the only jurisdiction in the world. This is not the only jurisdiction in the world. There are other jurisdictions where things are done differently, and they are better justices. So my question to you, Mr. Nominee, is if we continue to have it only by seniority, you get to that post so late you can't even carry out the reform that you want to carry out. That's my question. Thank you.
Take those sets of questions.
The court, and then the court will deal with it. Now, on the appointment of judicial officers, modalities leading to the appointment of a few undesirable elements. You see, I've read that in the pages of newspapers and things like that. I am not privileged with that kind of information. So I don't think I can help you with that. Because definitely it's a privileged information. But as far as the system court and the National Industrial Court and other high courts And then even in the Supreme Court, we have the retrofitting project that ought to have been finished by November last year, but it's ongoing. Very soon, when it is fully completed, everything will be, even the lawyer may not necessarily be in the court, it can be anywhere. You are doing your business. So we ourselves, we don't want to continue to write in long hands. And so they were on the High Court bench, Court of Appeal, the Supreme Court. So that is how they come in. If the bar feels that, but if the legal profession thinks and sees the need for removing it from the purview of the Legal Practitioners Privileges Committee, they will do that. But if the bar is to give itself that rank, I don't think it will be appropriate. There must be a higher body that should confer that rank. It's like you have the Council for Legal Education, responsible for training of lawyers. You have the body of benchers responsible for calling the new week to the bar and disciplining them. If you now say the bar should do this other thing, the bar will be incapacitated. The disciplinary committee of the bar is an arm of the body of benchers, which is the highest organ in the profession. So that is my take on that. The conservative system of appointing the Chief Justice and things like that, I think you should spare me that. Let me not answer that because it's not a one-on-one kind of a question. It's something that involves the totality of that profession. They have tested this side and they have tested this side. They should be in a position to know which one serves this country better, knowing fully well that it is not safe to politicize appointment to the bench. Doesn't matter whether it's in the High Court, the Court of Appeal, or the Supreme Court. The day you do that, you succeed in doing that, then say bye-bye to this country, because there will be no independence of the judiciary. Everybody will be clamoring for his candidate. There will be lobbying everywhere for appointment. Thank you.
Senator Samayon.
Thank you, Mr. President. Very distinguished colleagues. My name is Senator Sam. I represent Imo East in Imo State. This morning, Mr. Chairman, my Lord, I want to congratulate you. My name is Samuel, and I know that you are Samuel too. God called you 3 times, like me. My Lord, my question is just very simple. I was being asked by my constituents who heard that you are coming for screening today. They asked me to ask you, sir, is it right for INEC to issue a certificate of return to anybody on the order of a high court in a pre-election matter when the victim of such a judgment from the lower court is entitled for an appeal at the appeal court and the Supreme Court? That's my question, sir. Thank you.
I plead to be excused because it is coming up. It will be from there. It will go to the Court of Appeal. An opinion will be expressed. Then it comes to the Supreme Court. I might not even be on the bench. That may decide it. Thank you.
Senator Abdullah Dambaba.
Thank you, Mr. Chairman. My distinguished colleagues, my Lord, my question is this. Corruption, to my mind, is an attitude of the mind. but the judiciary is one of the most important institutions that can be used to fight corruption. Now, in recent past, we have witnessed judgments, conflicting judgments by courts of coordinate jurisdictions. What institutional reforms do you intend to bring in order to arrest this kind of ugly situation and bring back the integrity of the judiciary? That is my question, Mr. Chairman.
Let's try and ensure that we do not repeat questions already been asked. Senator Magnus Abbey.
Thank you, Mr. Chairman, my very eminent and distinguished colleagues. My Lord the nominee, let me first of all congratulate you on your nomination. Contrary to those who see the delay in your nomination one way, I see it as a very, very positive endorsement of your character, because it means that the president took his time and did not just nominate you because you are the oldest Supreme Court judge. If he was doing that, he would have done it long ago. But in view of the challenges that the judiciary is facing currently, he took his time, examined you, and then nominated you. So I congratulate you. But Mr. Nominee, sir, all is not well with the judiciary in Nigeria today. There are serious challenges facing the judiciary that has eroded the confidence of the average Nigerian in our judiciary. One of those challenges, sir, is the question of time. How long cases take in our judicial system? If you look at the example that my brother Senator Nala gave about what happened in the American judicial system, it didn't take the judiciary up to 48 hours to respond to what was clearly an emergency issue in the American system. But in Nigeria, that same issue would have taken us 2 years of laboring through the system before we would get a conclusion from the judiciary. Another thing, too, that is eroding the confidence of the average Nigerian in the judiciary is the question of precedence. I am a lawyer. When we started out practice, by just looking at earlier decisions of the Supreme Court, you could tell a client exactly what will happen to his case. But today, in today's Nigeria, you can have 10 Supreme Court decisions on a single issue, and people will still go to court and still get a different decision right from the High Court all through the Court of Appeal, and even sometimes up to the Supreme Court itself, where our own precedent is not followed by any of the courts. This particular issue has greatly eroded the confidence of the average Nigerian in the judiciary. The other issue I would also like to raise, Mr. Nominee, sir, is the question of the disobedience to court orders in this country. Except we are in a position where we can actually assure our citizens that the judicial process means something, and that an order of the court is an order of the court, not subject to review by any other authority in the land, and where there are consequences for those who step out of their way to disobey an order of the court, it will be very difficult to restore the confidence of the public in the judicial process. So, what can you do about some of these issues that are affecting the judicial process in this country? Thank you very much.
I will start with you, learned distinguished senator and learned gentleman. Disobedience to court orders, that is a problem for the legislature and the executive to handle. The judiciary will welcome that day that great day when in this country a decision is handed down by a court of competent jurisdiction, and even after its appeals had been exhausted, the rights of appeal had been exhausted, the order is carried out. That is the only day that the judiciary will truly become independent. So otherwise, it's just, a judgment is a piece of paper. If it cannot bite, the judgment must back and bite. That is the truth. So disobedience to court orders and things like that is a culture, is born out of the culture of impunity anyway. But I said you should excuse me not to go into that, please. Then judicial precedent. Judicial precedent. You know, I wish lawyers, practicing lawyers, will stay back, remember their training, and put it into practice. The processes are guided by precedents. That is what guides not only the judge, but the lawyers. When a lawyer knows that this is the trend of authority, list of authorities, on a particular subject matter, but he decides to just do anything, he crafts, in order to exhibit his intelligence or skill, he crafts a case trying to make it appear different from the norm. And then it starts to, the moment we do away with precedent, then the system collapses. That is why you have a tool in the process of litigation, which is distinguishing. You have to distinguish one case from the other in order to satisfy that court that that precedent does not apply to your case. And some of it is a problem of the lawyers, actually. Some of you assure your client that, look, I'll get you judgment. There's no way this court can decide otherwise. Are you really sure? You are not the judge. And the principles are there. We go by precedent so that whether we are alive or dead, the decision can be analyzed by generations yet unborn. And it should be found to be sound on the law and the facts. So when you talk, I'll tell you our experience, a bitter experience in the Supreme Court, in the political cases. You go to court at the election tribunal, you have the party and the candidate as a single party, retaining one counsel. A judgment is given. Then they go to the Court of Appeal. Split the parties. The party now has its own counsel. The candidate has his own counsel. And they have different appeals. And then in between, there are cases we have seen 7 appeals arising from one judgment. And it starts from the Court of Appeal. So some of the conflicting decisions you see when the panel is not careful enough, or the court is not careful enough to look through and see through the gimmicks, then you will have the conflicting decision. And I said that the conflicting decision is actually normal in adjudication. That is why we have the Court of Appeal and the Supreme Court to take care of such things. So when you come to the Supreme Court, what we now do is we gather all those appeals relating to that judgment and put them together, and then ask you to now tell us what your wahala is. Yes. See, because the intention is to continue to mess the judiciary, to mess the place up and things like that. It is not fair. Some of you know that the appeal should stop at the Court of Appeal, but you will find a way of bringing it to the Supreme Court. What for? That is why nowadays too, we say, okay, if you are here on the Supreme Court bench, wasting our time on a matter which should not be here, you should be personally responsible for the cost of the proceedings. Yes, because it means you are not advising your client properly. So, any other?
Senator Obina.
No.
For what now?
Been enlightened by some of the views expressed by the nominee before us. And I'll now put it to you, if it's a wish of my colleagues that during this presentation he can take a bow and leave. CJN nominee, you can come and take a bow.
Don't give them a bad name. Don't give them a bad name.
I will speak to him, then you join us. Because he wouldn't have left.